The New York Technology Council, for those who are not familiar with it, is an organization dedicated to promoting and supporting the technology industry in New York City and the surrounding area. This is the Legal Series, which is a series of events that we run on topics of interest to the technology community. And I am one of the board members of NYTEC. I also run the Legal Series. Before we get started this evening, we do want to extend a special thanks to Herman Miller, who has provided this great space for us this evening. Let's give them a big round of applause. And now to get on to tonight's session, this topic on business method patents after Bilski is something that I've certainly had in mind to do for some time now. I really want to thank Richard Raysman of Holland and Knight, who has taken the laboring oar here and pulled this event together with a great panel. And Richard, let me turn it over to you and introduce the panel.
Thank you. Well, welcome all of you here. And I think I'll put away the microphone at this point in time. We're going to do this as a panel discussion with a number of questions, and we'd like to get interaction. So this is an important discussion. There was the Bilski case, which was decided last year, which led into question what patents are actually patentable if they're an abstract idea and not what's called a transformation or machine of transformation test. And to some extent, Bilski limited patents because it rejected a particular patent as being an abstract idea. It was for a hedging risk and application of that concept to energy markets. But it also opened the door to tests that were not machine of transformation tests, and there were other tests. So to some extent, there was a lot of discussion at the time of Bilski for software patents and financial patents because of this patent being rejected as being too abstract. But the Supreme Court then opened the door to other types of tests. So we're going to have a discussion today, and one of the issues is whether or not Bilski actually limited patents or whether it expanded patents. So our first question here for the panelists, and we just wanted to, since this is mostly a non-legal audience, is to discuss what the judicial hierarchy for obtaining and enforcing patents are. And I should mention that Chuck, which was not part of your biography, Chuck also worked as an examiner in the patent office in his early career. So what is the judicial hierarchy for obtaining and enforcing patents? You want to start off, David?
Yeah, sure. So you have the U.S. Patent Office. How many here have obtained or sought to obtain patents? So you apply for a patent with the U.S. Patent Office, which is an administrative body branch of the U.S. Government. And what happens then if you want to enforce it based on infringement of the patent, you then go to a U.S. district court, right? Not a state court, but a district court. And then if you do not enjoy the decision by the district court, you can file an appeal. Now, in most district courts, you can appeal to the local circuit court. But the CAFC, which is a court appeals for the Federal Circuit in D.C., otherwise known as the Federal Circuit Court of Appeals, has exclusive jurisdiction for hearing all disputes on appeal from every district court. Yes. Every district court across the country. And then, of course, the CAFC, if you don't enjoy what they have to say, you go right to the Supreme Court, and they make they have the law that comes out of there that really governs what all courts beneath it must follow. So you're not going to fight a patent dispute in the state court. You're not going to fight it in the Second Circuit Appeals Court. You're going to fight it in the District Court, Federal CAFC, the Federal Circuit Court, and then the U.S. Supreme Court. And the same thing with the Patent Office. When you're trying to obtain a patent, and fight an examiner who always gets it wrong. Just kidding.
It's only been 21 years since I've been an examiner, but that's okay. I still take offense.
You're gonna wind up going through the hierarchy back to also this federal circuit. You go to the district court, you go to the Board of Appeals in the Patent Office, into the district court, which is going to be in D.C., then to the federal circuit, into the Supreme Court. And Bilski actually is a case that we'll address a little bit, which started off that way. Started off with somebody applying, the inventor Bilski applying for a patent for hedging bets. Patent Office examiner turning it down. The Board of Appeals turning it down. Then it went to the Federal Circuit, where they discussed, we'll discuss the machine of transformation test, which is why they turned it down. And then went to the Supreme Court, which made its decision and kicked it back to the Federal Circuit.
Isn't it a little unusual for a case to arise from the Patent Office to go all the way up to the Supreme Court?
Yes, extremely unusual for a number of reasons. One, it is incredibly expensive to talk before the Supreme Court. Because before you do that, you would have taken many steps, which cost tens of thousands, hundreds of thousands, $1 million. So it's very, very difficult to rise to the Supreme Court. I'm not sure the stat for it, but it's an incredibly small. Festo was another case, I believe, that a bunch of years before that, that dealt with prosecution history estoppel. Very few cases, though, wind up before the Supreme Court. It has to be a very important decision, and there has to be deep pockets involved. The average inventor is never going to go that far. They're going to raise their hands and give to what the examiners have to say, or maybe file an appeal and hope the Board of Appeals at the Patent Office side to them. Yes?
And what happens when there are other jurisdictions or if there are foreign filers involved? What happens in hierarchy?
So, in order to file at the U.S. Patent Office...
Repeat the question, sir.
So I guess the question is what happens if there are foreign filers? In order to file for a patent at the U.S. Patent Office, you have to have a U.S. Inventor, right? And so you're not going to have foreigners by themselves file for a U.S. Is that?
Well, unless the rules have changed,
No.
I don't think that's the
No,
case.
if you file in the U.S. and then also file in foreign country.
I mean, like an international application, right? So I think that was. So if you happen to file in the U.S. and also file like a PCT, in other words, you're filing an application in the Patent Cooperation Treaty.
Yes.
So you file. What happens is you have 12. Let's say you file. Everybody here know what a provisional application is? Raise your hand if you know what a provisional application is. So a provisional application means you file an application with the minimal amount of disclosure typically. It doesn't get published. You have 1 year from that point to file a regular utility application. And that application, at the same time, you can file for foreign protection through an international application in the Patent Cooperation Treaty. Then you're dealing with a whole body of law outside the U.S. And the Supreme Court's law is not necessarily going to have any impact. The Canadian Supreme Court, or the highest court in Canada, recently came out with a decision that really is not in line with Bilski. I believe it said that all business methods have the same ability to be subject to the same patent laws as every other invention. And meanwhile, that's not the case under Bilski, where you have the machine to transformation test. So once you exit the U.S., you're dealing with international treaties, and then the PCT application, the Patent Cooperation Treaty application, then you have to use that to enter the individual countries, and you're clearly subject to the laws of those countries. Some will just rubber stamp it and give you a patent. Some may do a tertiary type of review, and typically they don't follow. They're never going to cite the Supreme Court, U.S. Supreme Court, for why they may or may not grant you a patent.
If I could add to that.
Please.
In the UK, which is the patent law I'm most familiar with other than the U.S., you cannot obtain a patent on a method of treating an individual for medical treatment. And I think it's fair to say that, with the exception possibly of Canada, in the area of software-related inventions and business methods, the U.S. is pretty close to the extreme in terms of allowing those. And you probably are not going to be able to obtain a patent in many parts of the world. I doubt you'd be able to obtain a patent in England on the invention that Bilski tried to push through.
This
Well, why don't we go to the next slide?
Sure.
Let's move things along. And I like, what is a patent? And also, the next slide is also what types of patent claims exist. Chuck, could you give some background here? And since you're involved in the BlackBerry case also, I think it might be interesting to hear, since you were, on the ground there, to give a little bit of that background as well.
Sure. Let me deal with what you have up on the board first. The cynical view, as someone who's been both on the legal side and on the business side, is that a patent is nothing more than a ticket to litigate, and it gives you a day in court. And that, in the NTP litigation that RIM was involved with, was exactly, and really was the sole asset of our opponent in that case. It was a drawer company. It was a company that had no other assets, didn't produce anything. It had a patent that was, in many respects, a lottery ticket. And they convinced a federal court and a jury, and eventually appellate courts, that their lottery ticket should be paid off. That's a very cynical view based upon my experience in the BlackBerry litigation. But there are many reasons to obtain a patent. One is to use it offensively. And both manners of that term. In the case of the NTP litigation, it was both offensive in terms of having the team on the field with the ball. You can use it defensively. Bill Gates, as I told people at RIM frequently during our patent training, Bill Gates came to know through his experience with negotiating cross-license agreements with IBM that he had to have chips at the table. He had to have patents in his portfolio, so that when cross-license negotiations occurred between IBM and Microsoft, IBM didn't stack 10,000 patents, and Microsoft said, we have 3 or we have 100. And Bill Gates, I think it was in the late 90s, maybe you know better than I, dictated that every year there'd be a certain number of patent applications filed out of Microsoft so that they wouldn't be paying licensing fees to IBM, for example. There's other reasons. Venture capitalists tend to like to see that you have patents in your patent portfolio. And one of the things that I found curious, but it makes sense, when I was the chief legal officer of RIM, engineers and computer scientists and technologists love to have patents on their resume. And that's a double-edged sword, because you don't want them to have so many patents that someone swipes them away from you. But by the same token, there is a little bit of a attaboy, if you will, if you have a patent on your resume. It says that not only does your company appreciate the job you've been doing, but the federal government thinks it is worthy of granting a patent. So those are sort of 4 reasons why you would have a patent. Well, a patent is a document, is a government grant. It is issued by an individual country. There are some exceptions to that. We could have a whole session on the European Patent Office or some regional patent organizations, but just for tonight's purposes, just accept that it is a governmental entity, a single country that issues patents. In the United States, the term is 20 years from the date of filing. There are some variations on that. When I was a patent examiner back from 1985 to 89, the term was 17 years from issuance. And the United States government brought itself in line with the international community as a result of the negotiating of the what's called the TRIPS agreement, which is a World Trade Organization agreement that governs intellectual property law worldwide. It sets minimum standards of what you need to have in your patent law. Well, in all intellectual aspects of intellectual property law. When you file a patent application, and I saw many hands in the room, so for some of you this is not surprising, but you have to describe the invention in the patent application in a way that someone can understand how to make and use the invention. And what that meant from a practical standpoint, at least at RIM, and also I spent some days at Compaq in their legal department as an intellectual property counsel. It meant that the engineers, the scientists, we even had secretaries and others that actually contributed to patent applications. You don't have to be a technologist to be on a patent application. One of the lines of my resume is I have a patent that was issued to me as a result of a contribution I made at RIM, and I obtained a patent as a result of that. But we all had to participate on that patent application and describe it in a way that someone who was skilled in the art, someone who had the technology background or the business background, could pick up the document and make and use the invention. And that's one of the requirements under the U.S. patent law, and it's actually a requirement worldwide with variations, but essentially that is the standard. And then you have to have a set of claims. And a set of claims, and hopefully I'm not preaching to the choir here, but I presume that most people are not familiar with this process.
Correct.
Think of if you have a piece of property. Let's say you're fortunate that you have a Dutch ancestor that owned a piece of Central Park. And excuse me for being the naive person from Houston. But let's assume that was a possibility. You would have a deed to a little square of Central Park that described the metes and bounds of it. It described the borders. It described what you own. And in a patent, that description of what you own is the claims. And you can have, and we'll get to this in a moment, I believe, process claims or apparatus claims or method claims that describe the invention. And it says to the world, this is a no trespassing sign that I'm putting on my property. Stay away. And this is what you have to stay away from. And the debate in Bilski was whether or not those claims, that claim to that intellectual property territory as compared to real property territory, was allowable under the statute that says what you can obtain a patent for. And then, shall I go on?
Go ahead.
Usually the fights before the patent office and in court revolve around whether you've created something novel or non-obvious. What's something novel? No one has ever done it before. It's new. What's non-obvious? Well, no one has done something similar to it. And this is very basic, and there's tons of case law as to whether something is novel or something is non-obvious. And you need one of these two gentlemen or another person who has knowledge of patent law who can explain to you if you have a particular invention or if you're involved in a court case in which you're accused of infringement or in which you want to assert a patent application, to understand what it means that your invention was novel or that your invention was a non-obvious variant of existing technology. Over time, the standard for obviousness has shifted. It used to be in the ancient days that you had to have a flash in the pan, a spark of genius that distinguished your invention from the other invention that looked very similar. Trying to think if there's anything more I can say on this topic.
Why don't we go on to the next slide?
This was the other big question.
Sure, absolutely.
Difference between the method and the process.
Can you repeat the question?
Well, the question was, what was the difference between a method and a process patent?
Next slide.
Yeah, why don't we next slide?
Here we go, that's the next one.
Yeah, great question.
You must be clairvoyant.
Do you mind taking that one?
No, sure. Essentially, a process claim, patent that has process claims at the end. The patent itself is just a description of your invention. It could have a description of a method and a process in one disclosure. But at the end, where you have your claims, is what are you claiming? An examiner at the patent office is you want to see one or the other. Okay, you can't really do cross patent statutory class. It's called statutory classes, and you really can't go cross statutory classes in your claims. So,
Excuse me, David?
yes.
Can everybody hear in the back? Do we need a mic? No. Okay.
So the apparatus claim is going to be for this table. You have a table that has a plurality, because nobody likes to be limited to a particular number, of legs that raise a table from the ground and has a plurality of wheels, one with each respective leg. That's an apparatus claim. It's a structure that you can use a structure. Process could be how to make it, how to use it, a novel way, whether a lathe or whatever other plastic or wood, machine devices to make it or use it. In Bilski's case, which is the Supreme Court case decided last summer, it was hedging bets. So it was a method of understanding the risk of different investments, and based on this risk, contacting particular investors. And so it's gerunds, the term of art, gerunds, ing words are going to be used. If you read a claim, it has a lot of gerunds in it, it's a process claim. It's doing something, it's active. An apparatus claim is just simply a concrete structure, though not necessarily concrete, that describes the structure you're trying to take out of the market and put your stake around for your protection. Think so?
And to sort of put a little gloss on that, you sometimes hear method claims and you hear process claims. When you're sitting in the chair of an examiner, there are only method claims and apparatus claims. They may be couched in terms of a process, but usually it is you examine the method claim and make sure that each step of the method makes sense. Perhaps there are reasons in fields outside of my expertise where I could see where you would have a process with respect to a chemical substance, a process for producing formaldehyde with certain characteristics, for example, or a process for producing Teflon, which would have some other name other than Teflon. But I don't believe that there's any technical legal difference between a method claim and a process claim. It's just a matter of personal preference and the technology you're dealing with.
And take it one step further.
Sure.
Let's assume the product is a table, the process for manufacturing is table, but you've invented a new type of leg. Would that have to be a separate application?
I'll repeat the question.
So let's say the question is, let's say the process is for a table, but you've invented a new type of leg. Would you have to have a new claim for that?
Process for manufacturing.
A new process manufacturing the leg? Typically, if the method of manufacturing the leg is novel, then you'd want to actually have a patent directed solely to the method of manufacturing a leg for a table. There's no reason to have to encumber your broadest claim, which again defines the metes and bounds of your protection, over encumber it with structure like a tabletop, when you're really looking for just a method of manufacturing a leg capable of being used in a table.
Let me ask a question. Maybe Chuck, you can answer this. The question is this: we haven't talked much about software patents. So I'm running a hedge fund, and I have this great methodology of trading or whatever it is. I mean, that was actually Bilski case. How do I present that to the patent office as a software patent that would be patentable? And obviously, IBM, Microsoft, they all have software patents. What are they presenting to the patent office?
Typically, in the case of Bilski, you would present a process, a business process, or a method of performing that hedging operation. You might also, and part of my response is based upon what I was examining back in the 1985 to 89 timeframe. We had Merrill Lynch's cash management system come through. And they directed their claims to a computer system that performed certain processes. So it seems to me that you would still do that today, that Bilski hasn't changed anything from the days of the Merrill Lynch system, that you would put in a patent application with an apparatus claim, the apparatus being a computer system that had certain characteristics and performed certain functions. But the real claims, or the claims that you would prefer to obtain, I would think, would be the method process claims that step through the various processes and steps that you would go through in order to perform what Bilski thought he or the company did that was novel and non-obvious over what had been done before. Is that? I mean, you're closer to patent prosecution than I am.
Well, the hedge fund is about a hedge fund, basically. What you're
The
looking
hedge fund has a software process that makes it trade. Yeah, actually, that's a sort of a maybe that's a little not a great question, because if you have this great process in your hedge fund, you're not going to make it public with a patent, right?
trade secret.
It's trade secret.
Right.
But there are a lot of hedge funds, or it doesn't need to be a hedge fund. It could be IBM or Microsoft or a software company that has some kind of a software process.
Right.
And
So I guess one question is, what is the focus of your patent protection that you're seeking? If you're seeking protection based on contracts, the exchange of contract terms, or financial instruments, that may not be patent eligible anymore. It's left to be determined whether or not the hedge fund type of claim, besides Bilski, which was also overly broad, even if narrowed, can receive patent protection based on the uncertainty of, does it pass the machine or transformation test? And if it doesn't, how can you tell? It's unclear at this point. The Supreme Court left open in Bilski the fact that there has to be certain business methods which are patentable, despite the fact that they fail the machine or transformation test, despite the fact that they don't control a machine. If you have a computer that controls, these three Supreme Court cases, which came out in the 70s and early 80s, kind of like laid the foundation for how you could tell what's patent eligible subject matter. And you saw this a lot when you were an examiner, I'm sure, right? So just take a step back for a second, we have the Benson case in 72, which dealt with converting binary decimal code to binary on a computer. And in that case, really the most important thing is phenomena of nature is not patent eligible. Abstract ideas are not patent eligible. And a transformation, in that case, they said, is the clue to patent eligibility. Can you even get a patent when a machine is not included, right? So then came along the Fluke case, and let me know if I've gone to that too quickly, if you want me to repeat any of that. The Fluke case, which said that post-solution activity is not enough. That case dealt with a catalytic conversion process, an alarm system that reacted to a catalytic conversion process. And there weren't enough specifics in the patent claims to understand what was going on with the catalytic conversion process. And it was more that the Patent Office determined, the Supreme Court determined, you have basically claims directed to controlling an alarm unit that can be really applied to any alarm unit. Although they say here it's applied to a catalytic conversion process, we're now considering that a post-solution insignificant activity, because there really isn't much there to, why are you tying it to the catalytic conversion process? It's not clear, you haven't defined the process, you're just trying to get a patent really for the broader concept of controlling an alarm unit, right? And then the last case in Diamond v. Deere, which dealt with vulcanizing rubber, and that's really more where this comes into play, where you had a computer system that controlled equipment which was used to vulcanize rubber, okay? And that was held patent eligible. That was only one of those three cases where the outcome was held patent eligible, because you had a computer that was integrally tied to a transformation of some type of real thing, okay? So the problem with the Bilski case is that you didn't really have, you had more like the Benson issue, where you had this abstract idea of hedge funds, which are just something you learn in college in any economics class, that wasn't really tied, meaningfully tied. Like, for example, controlling another machine. It was just more considered a meaningless tie to a computer, that you're trying to preempt all uses of this conversion from binary coded decimal to decimal, which is what computers do all the time, across all fields, right? So with a hedge fund, it's questionable where it falls in with these three cases, and because really, that's all cases that we want to. If you want to get a patent, you have to make sure that you can argue to the patent office, to examiners, why you deserve a patent. You have to argue often based on case law, especially if the examiner doesn't buy your argument and you have to appeal. The Board of Appeals of the Patent Office wants to see case law because they're being guided by precedent, right, which is the Supreme Court case law and the Federal Circuit case law. So where does a hedge fund really come out, or some other type of software that deals with money transfers really come out? And it's questionable whether there's a meaningful transformation there tied to a computer in a meaningful way, and it's uncertain right now, I believe, as to whether or not, and I'll answer questions in a second, 1 second about this, and I'll answer your question. The Supreme Court in Bilski said, look, there has to be some business methods which are patent eligible, despite the fact that they failed the machine transformation test. But they left it up to the Federal Circuit to make a determination as to what those categories are. And the Federal Circuit so far has refused, or not refused, but has not had the opportunity to take up a case where they can make such a determination.
So let's take the question.
Yeah, the question.
You referred to the hedge fund situation, and you mentioned that might be a situation when someone might elect not to patent. So could you speak a little bit more about what are some of the situations? You mentioned, for instance, that it could be a trade secret as opposed to something being patented. So could you just elaborate a little bit on what are the situations when you would choose not to patent and what would be a trade secret?
That's a great question. It's a question, unfortunately, none of us have an answer to. But I'll give you. Sure. The question was essentially, okay, we know that certain things in Bilski are not patentable. But what is patentable, and when do you make the decision as to keep something a trade secret or try to obtain a patent? Let me deal with the second part of that question. Well, one of my jobs along the way, I was an intellectual property counsel at Compaq, and I had a responsibility for the consumer products group, and I had also a responsibility for the manufacturing wing of Compaq, how they went about putting chips on boards and computers, and shipping them out the door. Well, there were a lot of processes there. I mean, things as simple as how you spread the solder on the board. That, we could have probably obtained a patent on it, but we thought that it was unlikely that anyone would be able to reverse engineer or discover what our secret sauce was in order to obtain a patent and keep us from using that trade secret. You have to make a decision as to whether or not your trade secret is discoverable, or if it's something like the Coca-Cola formula, which seems, at least we all believe that the Coca-Cola formula has not been reverse engineered. That is the classic example when you're a law professor that you give for a trade secret, the formula for how to make Coca-Cola without cocaine these days. Do you derive economic benefit from the process and that you can continue to benefit as long as it's kept a secret? Are you able to keep it a secret? Those are all considerations as to whether you decide to patent your trade secret. And it's usually in the area of manufacturing processes or sources of supply. I would think that it would be very hard to obtain a patent, but I also come from the camp that anything is patentable if you put enough money behind it. It's just that what you get at the end of the day maybe something that won't hold up in court, but you can get almost anything through the patent office or through the appellate process. I think Bilski is a great example, and this is the cynical side of me coming through, of no one really understanding where patent law should head or the basics of patent law. If you read the Bilski decision, and my co-panelists may disagree with me, but to me, the Bilski decision was, well, really, this is not new or it's obvious. It really was more about that than whether it fell under the statutory subject matter, even though the case was wholly about whether or not 35 USC Section 101 permitted an issuance of a patent on this so-called technology. So in terms of making the decision as to whether or not you should proceed with a trade secret and obtain a patent, a good patent lawyer will tell you, well, let's analyze those steps. Can you keep it a secret? Do you derive economic value from keeping a secret? And are you prepared, if you obtain a patent on it, to have your secret go away after 20 years from filing? Let me answer the second part, and then we can take the other thing. And then, what is left to be patentable? There is a case that involved the development of microbes for eating oil off an ocean surface called the Chakrabarty case. And in that case, and I'm going to mangle the quotation, but it's something to the fact that anything made by man under the sun is patentable. And I'm a firm believer, and I am firmly in that camp. And you run similar tests, though. Obtain a patent is not cheap, and you need to put it in your budget if you decide that you want to have a patent application filed and taken through the patent office. And it doesn't matter whether you hire a lawyer from Houston, Texas, or New York City, it's still not a cheap proposition to obtain a patent. Once you've decided, when I worked at Compact, we routinely had convened committees of a combination of engineers and lawyers to decide, okay, we're going to file a patent application on this particular piece of this implementation of software to control an efficient use of memory because we think it can be reverse engineered. We think that we can derive economic value from it, and we might as well obtain a patent for the period of time that the patent allows for it, rather than just implement it and not try to protect it. Plus, in cross-licensing negotiations, it would be a nice patent to have in our portfolio if we can get it as broad as possible. So I don't know if that's helpful, but that's basically the process that I would go through if I were in a position of deciding what patents should be filed and not.
Let's take this question.
Sure.
Assume for a second that I have developed an algorithm for doing universal language translation. Can I patent that, or do I need to have a machine that runs that algorithm to do the patent?
We may have a difference of opinion here, but let me take the first shot. The first patent that I ever examined, application, as a patent examiner, had to do with synthetic language use in the oil field well drilling technology. They were translating electronic signals into a whole language of its own. And I mean, and I'm going back 26 years, so this may not be precise, but I persisted on as a patent examiner, and I said that's not statutory subject matter because it was merely an algorithm, and the way they claimed that invention, they were trying to preempt or keep others from using that algorithm, not just in that field, but in fields outside of oil technology. So the first thing you need to do is restrict your algorithm to a particular field of expertise. And then there is language in Bilski, and I'm going to turn to you on this, that suggests that you have certain magic language in your claims that maybe will get you over the hurdle at the patent office and get you a patent even if you don't have a machine or a physical transformation. And I probably would also argue that you have a physical transformation of bits and bytes in a computer when you're translating language. It's a stretch, but that would be one of the arguments that I would use. What do you think?
The Patent Office has taken the view since Bilski that if you put in your claims, which is again the section defining your patent protection, that you're seeking protection for a non-transitory program which executes the steps of X, Y, or Z, then you've overcome the Bilski issue. This is very new. It's based on guidelines which the examiners are implementing. It is yet to be tested in the courts.
David, let me interrupt. The question was about an algorithm, so where does an algorithm fit into your definition?
I don't know. That's the only way to get an algorithm through the patent office right now. I personally don't know if that passes a machine transformation test. Are you meaningfully tying your translation to a machine, or are you just using a field of use tying, which is, for example, using an algorithm to perform something you could do otherwise by reading a textbook, is not considered patent eligible under Diamond VD, right? Field of use limitations are not going to do it. Tying it to a computer by itself is not going to do it. So while the patent office is taking this one position that you can do it, I do question down the road whether you're going to be able to obtain patents for a process which really is something you could do by hand, but you're choosing to tie it to a computer. How meaningfully tied to a computer is it if you can do it by hand?
Don, you had a question?
Yeah, I'm confident you're going to get this in a slide or two, but I think you've been citing Bilski enough, and maybe you could explain the case history now behind Bilski for us that aren't familiar with it. Never mind.
We're working in tandem here.
So actually, this is. Am I going backwards? State Street came before Bilski, which said that any software can be patented. It can be patented, right? State Street said as long as it provides a useful, concrete, and tangible result. So in other words, if you have a software package that provides something that you can really grab onto, subject to subjective interpretation, but that's enough to get you a patent. So there were many patents. State Street came out in 1998.
Was the Supreme Court?
That was actually a Federal Circuit case. Many patents came out between 98 and 2008 when Bilski came out that said, there's so many patents out there that provide a useful, concrete, tangible result, not just related to software, but methods of swinging on a swing, methods of catching a bird by using a cat. I mean, all these different things that related to, really, like...
Method of taking a pill.
Yeah.
There's a unique way of taking a pill.
Golf swings. How do you enforce these patents? But, right? So then in Bilski came down to claims directed to hedging bets. And in 2008, the Federal Circuit, after hearing the appeal up from the Board of Patent and Examination of Appeals, the Patent Office, going up from the examiner, which rejected the claims, said that it has to pass the machine transformation test. If it doesn't pass the machine transformation test, you cannot get a patent. Despite, again, that the Fluke case that we mentioned earlier said that there can be certain patent eligible subject matter which does not pass the machine transformation test, right? So that's what the Supreme Court asked. Can you get a patent for something which doesn't pass the machine transformation test? Or is that the only test? And I think I flipped these backwards. So the Bilski case in the Supreme Court said, look, the machine transformation test is really the only test that is really an important test, but it's not the only test. In Fluke, back in 1972 or 1978, we said there has to be technology which fails a test but can still be patent eligible. We stand by that today. The machine transformation test is important, but it's not the exclusive test. Bilski still fails because, again, it's directed to an abstract idea that we learn. Hedging is learned in economics classes back in high school. There's no way to tie that to a computer or whatever to make it a significant tie to give you a patent. Ultimately, you have your non-patent eligible subject matter, possibly 102. It's just obvious. We've done this before.
103.
103, rather. 103, sorry. It's obvious. We've done this before for decades, centuries, whatever. Hedging is not a big deal. But they still, the case focused on the machine transformation test and said it's not the exclusive test. You have to consider other tests. So it's interesting to note, though, that the Supreme Court was very torn in this decision, right? So the Supreme Court, you had with 9 justices sitting en banc for the Bilski case, and you had your plurality, the majority decision, it was 5-4, said that, again, they reiterated the laws of nature, abstract ideas are not patent eligible, and the machine and transformation test is not exclusive. But then there was one, Scalia, I don't know if you know the Supreme Court justice, but Scalia pulled back from one of the court's decisions, sections, which Roberts signed on, saying that times change and therefore patent eligible subject matter, the scope of that has to change as well. Okay? So Scalia said, look, I don't know about this times change thing. We're tied by our precedents. We're tied by hundreds of years of case law. I don't know how much times change. But again, because of the Fluke case, which says you have to be able to have something which passes muster, we're going to still have to accept that. And also, Scalia did not join in a section which said that Roberts and Kennedy were concerned that not allowing patents for business methods as a whole would put a chill, unquote, quote, put a chill on creative endeavor and dynamic change. So there is this big concern about, look, things have really changed. We don't have the same technology that we had, in 1952 when the Patent Act was first, this Patent Act that we're following now came to being, or in 1793 and 1791 when the Patent Acts were first, written down for our country based on England's statute of monopolies and their patent protection. So, that's the background of Bilski, and so the question is again, how has Bilski? What really has Bilski done for us? It's shown us that it's really synchronized the three court cases from the 70s and 80s. Abstract ideas are not patent eligible, but on the other hand, like Fluke said, there has to be, the machine transformation test is there, but there has to be something eligible out there, undecided yet, what is patent eligible. And they actually punted. They said, we're leaving that up to the Federal Circuit to decide that. Maybe we'll revisit it if we don't like it, or if there are appeals to it. Yes.
Can you explain a little bit more about exactly what he was trying to patent? Because you mentioned it's a hedging algorithm, but a hedging algorithm to me seems very obvious, right? So what was the argument around it being not
Chuck,
obvious?
can you address that?
Well, I think you better address that. And I agree with you that really this case should have been about obviousness rather than, this was the wrong case to take up to the Supreme Court on statutory subject matter, I think. Because I suspect the justices were sitting there and going, for goodness sakes, we can't allow this to be patented. I mean, any economic textbook has this in it.
Right.
And that's just absolutely the wrong thing to say. Because that's not the test. Whether or not an economic textbook has it in it. The test is whether it's an abstract or idea, whether or not there's a machine or transformation. Do you have the
Claim?
the claim or the claim?
I do. A method for managing the consumption risk costs of a commodity sold by a commodity provider at a fixed price, comprising, which means, so you have your preamble, comprising means this is what it embodies. The steps of initiating a series of transactions between a commodity provider and consumers of said commodity, wherein the consumers purchase the commodity at a fixed rate based on historical averages, the fixed rate corresponding to a risk position of a consumer. And these are all basic, tenets of.
It's a futures contract.
Yeah.
Yeah, so far.
That's A. B, identifying market participants for the commodity having a counter risk position for the consumers. And C, initiating a series of transactions between the commodity provider and the market participants at a second fixed rate such that the series of market participant transaction balances the risk position of said series of consumer transactions. Just hedging bets. I mean, they don't actually even tie it to a computer. They're just talking about a method of hedging bets. So again, the Supreme Court took this on at a much larger review based on their precedent, the 3 cases we discussed before, but said ultimately that, interesting quote here about hedging is a fundamental economic practice long prevalent in our system of commerce and taught in any introductory finance class. Thus, the concept of hedging, as claimed, is an unpatentable abstract idea. So abstract, now you say, what is an abstract idea? Well, the Patent Office actually has enumerated some tests of what it considers abstract. But I guess what we can consider abstract is something that's really well known, doesn't require a computer, just is something that we do comfortably without being told what it is an abstract idea.
Unfortunately, the Supreme Court didn't tell us what an abstract idea is.
Right.
And so in answer to the question of the gentleman behind you, I have no idea if you implement an algorithm for a universal translator, whether or not if it went to the Supreme Court would say that's an abstract idea or not. Translation exists. You know, we speak different languages, and there's a need to translate from one to another. But having said that, if you have the risk capital available, and that's how I believe you should view the whole process of patenting, is you do a risk-reward analysis every time you file a patent application. You know, what's the risk of not patenting, and what's the reward if you do obtain the patent? And put in your budget sufficient funds so that the crown jewels of your company, those that you wouldn't exist but for those patents or that technology, you know, lay the money down on that bet rather than laying the money down on peripheral bets that may pay off extremely well because you can extract a license from Microsoft or Intel or some chemical company. Sort of guard your resources. If any of you play Texas Hold'em poker, you don't go all in on the first bet, even if you have the best hand at the table. You think you almost hedge your resources, if you will, and you make sure that you, if it's core to your business, then you file a patent application on it and let the chips fall where they may. To continue my strained analogy. But if it's not core to your business, then you have to determine whether or not you want to risk that capital to try to chase a patent that could pay off in the long run tremendously well.
Now, the Patent Office has enumerated, like I said, a bunch of different tests for determining what's an abstract idea. And that's really kind of like all of us are trying to figure out until the Federal Circuit or maybe the Supreme Court again sees a case in this. What is an abstract idea? I'll go through this quickly. Did you ever? Sorry. Did you?
Just a quick question. Bilski's claim started with a method for managing.
Yes.
In your experience, how many times has something like that been received favorably in the Patent Office? Start a method for managing that specific frame.
I filed them myself. How many times? I mean, before Bilski. I think that before Bilski it was useful, concrete, tangible results test, and if you can argue that. Before 2008, there was a chance to get it through the Patent Office. Now, I think it's less likely. You're going to have to, I think you want to attach it to a computer program.
One other thing you possibly could do, and again, you have to consult with a patent lawyer to see if they agree with me. So this advice is worth what I'm charging for it, which is nothing. And that is, I used to be an associate at Jones Day many years ago, between my time at the Patent Office and my time at Compact. And we had a client that had a software program for creating greeting cards. And one of the claims that I put in the patent application was the actual physical greeting card. That was a product by a process. And if you have a product at the end of the process, or the alternative claim, and I unfortunately, I don't know if this ever made it through the Patent Office, so this is pretty defective advice, but you need a patent lawyer that's willing to think outside the box in these areas in which you have very tricky subject matter jurisdiction questions or subject matter questions. Whether it's a universal translator or a Bilski method, you do everything you can to cloak it so it doesn't look like Bilski. You don't use that language, I don't think. But the other thing that you can do is you could say a medium, a CD, or a storage in a computer that embodies a program with the following characteristics. And that, again, is your product by process. And so you're patenting. No one can implement your process of making a greeting card easily without having either a CD, or in those days a floppy disk, or a memory chip on a computer. So if you can capture a memory chip with those characteristics, or a CD,
is an algorithm an apparatus or a process?
It's neither.
What's the question?
Is an algorithm an apparatus or an apparatus?
Or a process?
An algorithm I would take to be, when it comes to software, an algorithm is a high-level discussion of what the software does. So that would be more, if it was patent eligible, it would be under the process. That's what I would say.
I would agree with that.
Yeah, it's not an apparatus. An algorithm is going to be steps. When you try to get a patent for software, you're not looking to get a patent for the code. There was a time when people would attach tens of hundreds of pages of code to the back of a patent application because they felt that's what they needed. But now you just need an algorithm, which is a flow chart of what the code does. Because there's so many different languages of code that can accomplish the same thing. So, yes?
I'd like to sort of nail that down if I can, speaking as a computer scientist. I mean, an algorithm is not what it does, but how it does it specifically. And if I could get to a real computer science specific example, if I come up with an algorithm for sorting at a very basic level, like how your database or how your Excel spreadsheet sorts, is that patentable?
Well, first of all, for the algorithm aspect, you want to put it like in a PowerPoint flow chart. You have your if-then statements, you have your whatever statements. You want to put it down in a nice flow chart, with all the different, connectors, interconnections, feedback loops, and whether or not that's patentable, sorting.
Actual method of sorting at a very basic fundamental level, at a computer science level.
So let me just read a couple of, now this is Patent Office interpretation of Bilski, which is not really rule of law, but it's important if you're going to file a patent application.
But let me just interject.
Sure.
It's not rule of law, but that's the rules they're going to be applying, and that's what increases your cost of obtaining a patent in this area.
So we have basic economic principles and theories, including hedging, insurance, financial transactions, and marketing, basic legal theories, contracts, dispute resolutions, and rules of law, mathematical concepts, algorithms by themselves, not tied to a machine so that they control a machine, like in the case what we discussed where you have the curing rubber, spatial relationships, geometries, mental activities, forming a judgment, an observation, evaluation, or an opinion, interpersonal interactions or relationships, such as Facebook, teaching concepts, memorization, repetition, human behavior, exercising, because there have been patents before Bilski that provide useful, tangible, concrete results, wearing clothing, following rules or instructions, as well as instructing how businesses should be conducted. So if it falls within one of those broad categories, right now the patent examiners may not allow that to go through. An algorithm by itself, if it's meaningfully tied to a machine and provides a meaningful transformation, such as, again, controlling a computer attached to an oven which controls the vulcanization process of rubber, that's all you could see what's going on there, versus, again, the catalytic converter claims, which the catalytic conversion process wasn't meaningfully even defined in the specification, and you really just had nothing more than controlling an alarm unit. So you got to see where you fall in. An algorithm, can it be patented? Yes. But it depends on where it falls in the scope of what's been held patentable versus what's not been held patentable.
Let me ask about the future. Okay, we have 10 minutes left, so we've discussed what Bilski says, we've discussed the past, so let's look into the future. And I guess my view is, because the Supreme Court really left this open, saying that the machine transformation test is not the sole test, that to some extent it could broaden things that can become patentable. On the other hand, it would seem to me, because now the patent office has come out with interim regulations and so on, that it's going to be more difficult to start getting things through the patent office. So Chuck, what do you see happening in the future?
I think you're right on both counts. We have a confused decision, in my opinion, from the Supreme Court. We have a patent office who is still maintaining its bias against issuing patents, unless it falls into the classic areas that we are all used to having patents on. If it's a software embodied process that controls something at the end, then you're probably fine. When I was a patent examiner, and I know you asked me to talk about the future, but sometimes you have to understand history in order to project what the future is. When I was a patent examiner, AT&T applied for a patent on a method of allocating resources. And it was very useful in queuing up calls and data and communication systems. But it was essentially an operations research algorithm that replaced what was known as the simplex method. And their patent lawyer was very good. He or she, it was a he, couched the claim language in such a way that I felt, as the examiner, it was statutory subject matter. Given the Bilski case and given the guidelines from the patent office, I don't think I, as an examiner, would have been able to issue that case these days. And more so because of the guidance from the patent office now.
I would think the examiners are going to become a little gun shy now as a result
The examiners,
they're going to push back.
It will take, I think, 5 years for this to sort out. Does that mean that you don't apply for patents on items that are on the edge if it's core to your business? No, you should go ahead and budget it and apply for it. And do the analysis as to what the risk and reward is. But expect that it's going to be a long, tedious process, and it may not take your patent to be a court case, but it may take someone else's patent application to clarify the law here from the Federal Circuit. Well, that's my gut feeling.
What do you think the future holds, David?
So just kind of, it takes probably, with business methods, several years before you file a patent application and you actually hear back from the patent office. In 2007, the KSR case came down, which really revamped whether something is obvious or not, which is not what we're talking about here. But this past year, 2010, they came out with they came out with interim guidelines in 2007, and then secondary interim guidelines in 2010, based on about 18 to 20 different Federal Circuit case decisions, which really helped understand that the KSR decision, which seemed very difficult and omnibus for all of us to try to figure out back in 2007, that it wasn't as broad-reaching as we all thought. And you can't get many patents, despite the fact that we were concerned that you could get nothing back in 2007 because everything was going to be held obvious. It may be that 3 years from now, the Federal Circuit will come down with enough decisions to show that Bilski didn't have as much bite as we'd all have been concerned about. That really is very easy to navigate. Well, I say easy, very manageable to navigate. And that based on a second set of patent office interim guidelines which the examiners are going to follow, we're all going to be able to navigate the path to getting patents for you and for our clients, and it's worth filing a patent application now, which may not be examined for several years. And also, you have to remember, you have only 1 year to file a patent application from your initial disclosure. So you got to make sure that you file your provisional or utility application. You don't want to let that go once they go, you can never get that time back after your initial disclosure. We can talk more about that after, offline, about your time restraints. But you really, I would not necessarily throw everything to the side and say, well, I can't get a patent now because of what these patent office interim guidelines are, because by the time your application gets to the patent office examiner, things can be entirely different.
Yes, right on there. Yeah, you.
Okay, so you described earlier that a patent can be, an application can be interpreted as a ticket to litigate, and later you mentioned trade secrets. I'm a software developer, and I routinely get presented by clients with boilerplate saying, amongst other things, respect our trade secrets, and then of course no proper declaration or itemization of those trade secrets follow. I'm wondering if you can speak to the enforceability of I never really know what context I should interpret trade secrets in.
Trade secrets are best.
Chuck is going to be the last comment, all right? So this will be, we're finishing up with your comment. So get as much in there as you need to get. All right?
No pressure.
You're not going to have a chance to speak again.
Trade secrets are best protected by non-disclosure agreements that specify with excruciating detail what the trade secrets are. If I were advising someone who presented to you a statement that says respect our trade secrets, I would say to them, A, what are those trade secrets? B, do you have non-disclosure agreement with this gentleman sitting in the fourth row or fifth row? And if you do, have you disclosed with enough specificity so that he is on notice that he is disclosing inadvertently your trade secrets or deliberately, or using them to his advantage to your disadvantage? So, I mean, based upon what you've told me so far, I would say that is not an effective way for them to protect their trade secrets. Now, ignore their request at your risk. And if it's the old rule that probably your mother or someone in your family told you, if it just doesn't seem right, don't do it. Because what you don't want to do is end up in court trying to run the argument the other way and say, they didn't tell me that this was a trade secret. I had no idea it was a trade secret. Yeah, I thought it was valuable to them, but I thought I could still use it. Then you start to get, if you're before a jury, you're going to have some problems there.
Okay, well, I want to thank our panelists for their presentations. Before we start, I have an article here, a handout, anybody which sort of discusses the Bilski case. So if you're interested, you can come up and get one afterwards. Paul, you want to say something?
Yeah, just again, thanks to Richard, Chuck, David for this evening. Thanks to Herman Miller for the space. Anyone who would like to be on the mailing list for future events, make sure you leave me a business card.